In this session, we will see about the pledge. Pledge is defined in section 172 as it is a bailment of goods as security for payment of debt or performance of a promise. It is some securities created by bailment. What is a bailment? We have already seen in another session. Bailment is a delivery of goods for some specific purpose. For example, watch is given to the watch repairer. So it is retained for some specific purpose. He has a right to retain the possession of that goods. Here, goods are handed over to the another person. Goods are delivered to the other person as to be kept as a security for payment of debt or performance of a promise. So seeing the definition, we can say there are two things are essential. One is delivery of goods, next is the presence of a contract. We will see one by one. Delivery of possession, it can be handed over to the other person. Sometimes this may be consecutive delivery also. You cannot hand over the entire thing. For example, a trader wants to pledge his 100 bags of rice to the financier, a banker. He cannot go with the bags and deliver it. So what he will say, we will put everything in a warehouse. He will obtain a warehouse receipt. Warehouse receipt will be handed over to the banker. And the warehouse people will be intimated that the goods with you are pledged to the banker. He will note his charge in his books. So delivery may be direct or delivery may be consecutive by handing over the documents of title to goods. If the goods are with a third party, notice should be sent to the third party mentioning this pledge so that he can have a control over the goods, and in case the other person demands it, he can give it. Next is in pursuance of a contract. There must be a contract. Only when there is a contract, there will be a obligation to pay the debt or obligation to perform the promise. So existence of contract is necessary. Next is the delivery and the advance need not be simultaneous. It may be on the previous day. In one case, Bluntel versus Attenborough. In this case, a lady came with the gold that was given to the person. He told, I will assess and tell you tomorrow. By the time this person went to the other person and pledged it for 1,000 pounds sterling, came back and gave the lady only 500 pounds sterling. When the lady came to redeem the gold with the 500 pounds sterling, the gold was not with the person, it was with the third person. The lady contended, I have not created a mortgage, created a pledge in favor of this person. So he has no right to retain the gold. But the court held, you have handed over the gold to this person with the intention of keeping the gold as a security. That means a pledge is there. So when the pledge is there, he has a right to pledge to the other person. It was held like that. That is, intention to keep the goods as a security is required. It need not be on the same day of the advance. Next, we will see the right of the pawnee. Pawnee means the person who has taken the goods as security. Section 173 says the right is to retain the possession of the goods. He can retain the possession. He can be a retainer of the goods so long as his money is not paid. The banker has a right to retain the gold pledged to him. The retain so long as the advance is not paid. Once the money is paid, he has to release it. He has to retain it. Next is section 174 says the pledge may cover the subsequent advance also unless contrary agreement is there. For example, a person with 50,000 worth of gold pledged it, got 10,000. Subsequent to that, he was in a financial difficulty. He will go to the same person, ask for some more money. that money will also be covered by the gold already given. 50,000 worth of gold will cover the further advance also, unless there is a contrary agreement to them. Next, section 175 says the person who has taken the goods has the right to spend money on preservation of the goods. He has a right to get back the money, reimbursement. But for this expenditure, he has no right to retention. He can only file a suit for recovery of the money. For example, goods are there. The company may have, the finance company may have spent on godown rent. In that case, they can recover godown rent also. Next, section 176 deals with the right to sell it. For example, 50,000 gold. This person has already availed 40,000. With all interest and all, it already touched the 50,000. What the person will do? The person who has financed it, he will call the person, you remit the money because the gold value is less and your outstanding is more. If he is not remitting, the company or the banker will go for selling the gold. Section 176 is the right to sell it. It gives two rights to the person. He can proceed against the person or against the property or against the both. Against the property means right to sell. Against the person means he can file a suit in the court. He can file a suit or he can sell the goods. If he is selling the goods, he has to give reasonable notice to the person who has pledged it. Reasonable notice is required. Only after reasonable notice. For example, I have given 3 months time. He has not repaid within 3 months time. So immediately he cannot sell it. I gave you 3 months, you have not paid, so I am going to sell. That's not correct. What he has to do? He has to send a notice. 15 days time. You have to redeem the gold. But if he is not doing that, then he can go for sale. Now we will see the pawner's right. Section 177. What is right? His right is to redeem the property. Redeem the goods. He gave the gold. He got money. 3 months time given. Not paid. Then what this person will give? He will give a notice. Another 30 days. Then also not paid. Then this person is arranging for a sale. Then the pawner came. This is my gold. What is your dues? I will make a payment. So he has a right to redeem the property, redeem the loan, take back the goods, be any time before the sale. He can come to the place where the auction is going to be conducted. Even there he can take the goods back by making a payment. Of course, he has to make additional payment for the notices, for the proceedings for the sale. He has to make a payment, but his right is not over once the time is credit period is over or once the notice period is over. He has a continuing right till the sale. Once the sale is confirmed, he has no right to claim back the goods. Before the sale, he can redeem the goods. Now we will see who can pledge it. Naturally, the owner can pledge it or the agent with his authorization can pledge it. But Act says 2-3 persons may also pledge it. Section 178 says the mercantile agent can pledge it. Mercantile agent means a person who is authorized by the other person to keep possession of the goods, to sell or to buy some. As an agent, if he is authorized to do that, he can mortgage it. Possession should be with him. It should come in the normal course of business, not by cheating other things. In normal course of business, it is with the person. In good faith, it should have been received, you should have been given, and in good faith he has to make a pledge. Next is section 175A. It says anything under voidable contract can also be pledged. For example, a person in one case, it is a very good example. Philip versus Brooks Limited. One person went to the company, showed some checkbook. He told, I am a big shot and I am going to purchase gold. They gave the check. Gold was delivered. Immediately with that gold, he went to some other shop and pledged it. And this banker, the shop saw the check returned after 2-3 days. Then they went to that, traced out that the gold is with the pledger. Pawnee. It was pledged. They went to the court. They said that this is a contract. He has obtained it fraud, so no right for this person. But the court held it is not like that. It is a voidable contract. He has a right so long as the contract is not avoided. Once the contract is avoided, his right goes. He is having a right till the contract is avoided. This is a fraud. A contract is avoidable. If it is not avoided, then the other person has a right. He has a right to pledge it. So any person having the goods under voidable contract can pledge it before the contract is avoided by the other person. Next is a pledge by the pledgee. For example, a financier has taken a gold, 50,000 rupees gold, advanced money 10,000 rupees. But this person is in urgent need of money. What he will do? He can take the goods to the another person and pledge it. His right to pledge is restricted to his interest. If he has only 10,000 rupees advance, then he can pledge it for 10,000. If he is pledging the gold for further sum, he is personally liable. He can pledge only for 10,000 rupees. If he is taking 30,000 rupees, that means he has to pay 20,000 rupees from his pocket. This person can pay only 10,000. Now in the next session we will see some other topic.